If you're a parent in Massachusetts and there's no custody agreement, so either you're with the other parent of your child or you're not with the other parent of your child, but if there's no family court order, you can pretty much do whatever you want. Within reason, of course, and within the bounds of the law. But in terms of traveling, taking your kids somewhere, you don't need the other parent's permission. Of course, it's good practice and you should do it if you can, if it's reasonable. But if you were to take your child out of state or even out of country, there would be no criminal violation of the law. Even if the other parent doesn't want you to leave, if you leave, you take the child, there's not much you can do. So if you don't trust the other parent to be around the child or to take the child somewhere else, then your best bet is to get a family court order and restrict them from going. Then you might have more recourse. In Massachusetts, there is a law called Custodial Interference of a Relative. In order to prove the offense, the prosecutor would have to prove 5 elements beyond a reasonable doubt. First, they would have to prove that the defendant was a relative of the child. Second, they would have to prove that the child was less than 18 years old at the time of the offense. Third, the prosecutor would have to prove that the person either took the child away with the intent to deprive the parent or guardian of the child permanently or for a protracted period of time, or that they removed the child from the lawful guardian or parent. Fourth, the prosecutor would have to prove that the defendant did that without any lawful authority. And finally, the prosecutor would have to prove that the person either took the child outside of Massachusetts or put them at risk of being harmed. If you're convicted of custodial interference of a relative, you could face a maximum incarceration of up to 1 year if the offense and the facts therein show that you took the child outside the Commonwealth of Massachusetts. On the other hand, if the facts show that you put the child in a risk, a danger, during the duration of the crime, then you could face up to 5 years in prison. Now, of course, there are possible defenses, whether or not the guardian gave you lawful authority, whether or not there was a court order in place preventing you from doing what you did. All of these are factors, and obviously, if you're charged with this crime, you have to consult with an attorney. But hopefully this is helpful in understanding what the crime of custodial interference by a relative actually means.